Minister, Theresa May, the virtual bot, reads the draft agreement on the withdrawal of the United Kingdom of Great Britain and Northern Ireland from the European Union and the European Atomic Energy Community. Part 1 is the French version of this draft. Part Withdrawal draft agreement, running whopping 585 pages, perhaps more considering the annex, is so freaking complicated that no reasonable person, busy with daily work of making ends meet, can be expected to understand and to make a rational decision.
Et d'Irlande du Nord de l'Union européenne et de la Communauté européenne de l'énergie atomique.
The withdrawal vote reads.
Thank you very much for that warm welcome. Now, can I just say, you will have to excuse me if I do cough during the speech. I've been up all night supergluing the backdrop. Mind you, I suppose if anything happens, I could just ask to borrow the voice of Geoffrey Cox. Wasn't that fantastic?
Part 1 Common Provisions Article 1 Objective. This agreement sets out the arrangements for the withdrawal of the United Kingdom of Great Britain and Northern Ireland, United Kingdom, from the European Union, and from the European Atomic Energy Community. Euratom. Article 2 Definitions. For the purposes of this agreement, the following definitions shall apply. Union law means I. The Treaty on European Union. 2. The Treaty on the Functioning of the European Union, TFEU, and the Treaty establishing the European Atomic Energy Community, Euratom Treaty, as amended or supplemented, as well as the Treaties of Accession and the Charter of Fundamental Rights of the European Union, together referred to as the treaties. II. The general principles of the Union's law. III. The acts adopted by the institutions, bodies, offices or agencies of the Union. I. The international agreements to which the Union is party and the international agreements concluded by the member states acting on behalf of the Union. V. The agreements between member states entered into in their capacity as member states of the Union. V. Acts of the representatives of the governments of the member states meeting within the European Council or the Council of the European Union. Council, VI. The declarations made in the context of intergovernmental conferences which adopted the treaties. B. Member states means the Kingdom of Belgium, the Republic of Bulgaria, the Czech Republic, the Kingdom of Denmark, the Federal Republic of Germany, the Republic of Estonia, Ireland. The Hellenic Republic, the Kingdom of Spain, the French Republic, the Republic of Croatia, the Italian Republic, the Republic of Cyprus, the Republic of Latvia, the Republic of Lithuania, the Grand Duchy of Luxembourg, Hungary, the Republic of Malta, the Kingdom of the Netherlands, the Republic of Austria, the Republic of Poland, the Portuguese Republic, Romania, the Republic of Slovenia, the Slovak Republic, the Republic of Finland and the Kingdom of Sweden. D. Union citizen means any person holding the nationality of a member state. D. United Kingdom national means a national of the United Kingdom, as defined in the new declaration by the Government of the United Kingdom of Great Britain and Northern Ireland of December 31, 1982 on the definition of the term nationals, one together with Declaration No. 63 annexed to the final act of the Intergovernmental Conference which adopted the Treaty of Lisbon. 2. E. Transition period means the period provided in Article 126. F. Day means a calendar day, unless otherwise provided in this agreement or in provisions of Union law made applicable by this agreement. Article 3 Territorial Scope 1. Unless otherwise provided in this agreement or in Union law made applicable by this agreement, any reference in this agreement to the United Kingdom or its territory shall be understood as referring to the United Kingdom. 1 OJC 23, January 28, 1983, page 1, 2 OJC 306, December 17, 2007, page 270, b. Gibraltar, to the extent that Union law was applicable to it before the date of entry into force of this agreement. C. The Channel Islands and the Isle of Man, to the extent that Union law was applicable to them before the date of entry into force of this agreement. D. The sovereign base areas of Akrotiri and Dhekelia and Cyprus, to the extent necessary to ensure the implementation of the arrangements set out in the Protocol on the sovereign base areas of the United Kingdom of Great Britain and Northern Ireland and Cyprus annexed to the Act concerning the conditions of accession of the Czech Republic, the Republic of Estonia, the Republic of Cyprus, the Republic of Latvia, the Republic of Lithuania, the Republic of Hungary, the Republic of Malta, the Republic of Poland, the Republic of Slovenia and the Slovak Republic to the European Union. E. The overseas countries and territories listed in Annex II to the TFEU having special relations with the United Kingdom 1, where the provisions of this agreement relate to the special arrangement for the association of the overseas countries and territories with the Union 1 Anguilla, Bermuda, British Antarctic Territory, British Indian Ocean Territory, British Virgin Islands, Cayman Islands, Falkland Islands, Montserrat, Pitcairn, St. Helena, Ascension and Tristan da Cunha, South Georgia and the South Sandwich Islands, and Turks and Caicos Islands too, unless otherwise provided in this agreement or in Union law made applicable by this agreement. Any reference in this agreement to member state, or their territory, shall be understood as covering the territories of the member states to which the treaties apply as provided in Article 355 TFEU, Article 4 Methods and Principles relating to the effect, the implementation and the application of this agreement. 1. The provisions of this agreement and the provisions of Union law made applicable by this agreement shall produce in respect of and in the United Kingdom the same legal effects as those which they produce within the Union and its member state. Accordingly, legal or natural persons shall in particular be able to rely directly on the provisions contained or referred to in this agreement which meet the conditions for direct effect under Union Law. 2. The United Kingdom shall ensure compliance with paragraph 1, including as regards the required powers of its judicial and administrative authorities to disabling inconsistent or incompatible domestic provisions through domestic primary legislation. 3. The provisions of this agreement referring to Union law or to concepts or provisions thereof shall be interpreted and applied in accordance with the methods and general principles of Union law. 4. The provisions of this agreement referring to Union law or to concepts or provisions thereof shall in their implementation and application be interpreted in conformity with the relevant case law of the Court of Justice of the European Union handed down before the end of the transition period. 5. In the interpretation and application of this agreement, the United Kingdom's judicial and administrative authorities shall have due regard to relevant case law of the Court of Justice of the European Union handed down after the end of the transition period. Article 5. Good faith. The Union and the United Kingdom shall, in full mutual respect and good faith, assist each other in carrying out tasks which flow from this agreement. They shall take all appropriate measures, whether general or particular, to ensure fulfillment of the obligations arising from this agreement and shall refrain from any measures which could jeopardize the attainment of the objectives of this agreement. This article is without prejudice to the application of Union law pursuant to this agreement, in particular the principle of sincere cooperation. Article 6 references to Union Law 1, with the exception of Parts 4 and 5. Unless otherwise provided in this agreement, all references in this agreement to union law shall be understood as references to union law, including as amended or replaced, as applicable on the last day of the transition period 2, where in this agreement reference is made to union acts or provisions thereof. Such reference shall, where relevant, be understood to include a reference to union law or provisions thereof that, although replaced or superseded by the act referred to, continue to apply in accordance with that Act 3. For the purposes of this agreement, references to provisions of union law made applicable by this agreement shall be understood to include references to the relevant union acts supplementing or implementing those provisions. Article 7 references to the union and to member states 1. For the purposes of this agreement, all references to member states and competent authorities of member states and provisions of union law made applicable by this agreement shall be understood as including the United Kingdom and its competent authorities, except as regard the nomination, appointment or election of members of the institutions, bodies, offices and agencies of the Union, as well as the participation in the decision-making and the attendance in the meetings of the institutions. B. The participation in the decision-making and governance of the bodies, offices and agencies of the Union. C. The attendance in the meetings of the committees referred to in Article 3.2 of Regulation (EU) No. 182/2011 of the European Parliament and of the Council 1, of Commission expert groups or of other similar entities, or in the meetings of expert groups or similar entities of bodies, offices and agencies of the Union, unless otherwise provided in this agreement 2. Unless otherwise provided in this agreement, any reference to the Union shall be understood as including Euratom. Article 8 Access to network, information systems and databases unless otherwise provided in this agreement. At the end of the transition period, the United Kingdom shall cease to be entitled to access any network, any information system and any database established on the basis of Union law. The United Kingdom shall take appropriate measures to ensure that it does not access a network, information system or database which it is no longer entitled to access. 1 Regulation, EU, No. 182/2011 of the European Parliament and of the Council of February 16, 2011 laying down the rules and general principles concerning mechanisms for control by member states of the Commission's exercise of implementing powers. OJL 55. February 28, 2011. Page 13. Part 2 Citizens' Rights Title I General Provisions Article 9 Definitions for the purposes of this part, and without prejudice to Title III, the following definitions shall apply. Family members means the following persons, irrespective of their nationality, who fall within the personal scope provided for in Article 10 of this agreement. I. Family members of Union citizens or family members of United Kingdom nationals as defined in point 2 of Article 2 of Directive 2004/38/EC of the European Parliament and of the Council 1 Directive 2004/38/EC of the European Parliament and of the Council of April 29, 2004 on the right of citizens of the Union and their family members to move and reside freely within the territory of the member states, amending Regulation EEC No. 1612/68 and repealing Directive 64/221/E, 68/360/E, 72/194/E, 73/148/E, 75/34/E, 75/35/E, 90/364/E, 90/365/E and 93/96/E. OJL 158. April 30, 2004. Page 77. II. Persons other than those defined in Article 3.2 of Directive 2004/38/EC, whose presence is required by Union citizens or United Kingdom nationals in order not to deprive those Union citizens or United Kingdom nationals of a right of residence granted by this part. B. Frontier workers means Union citizens or United Kingdom nationals who pursue an economic activity in accordance with Article 45 or 49 TFEU in one or more states in which they do not reside. D. Host state means I. In respect of Union citizens and their family members, the United Kingdom, if they exercise their right of residence there in accordance with Union law before the end of the transition period and continue to reside there thereafter. II. In respect of United Kingdom nationals and their family members, the member state in which they exercise their right of residence in accordance with Union law before the end of the transition period and in which they continue to reside thereafter. D. State of work means I. In respect of Union citizens, the United Kingdom, if they pursued an economic activity as frontier workers there before the end of the transition period and continue to do so thereafter. II. In respect of United Kingdom nationals, a member state in which they pursued an economic activity as frontier workers before the end of the transition period and in which they continue to do so thereafter. E. Rights of custody means rights of custody within the meaning of point 9 of Article 2 of Council Regulation, EC, No. 2201/20031, including rights of custody acquired by judgment, by operation of law or by an agreement having legal effect. 1 Council Regulation, EC, No. 2201/2003 of November 27, 2003 concerning jurisdiction and the recognition and enforcement of judgments in matrimonial matters and the matters of parental responsibility, repealing regulation, EC, No. 1347/2000, OJL 338, December 23, 2003, page 1. Article 10 Personal Scope 1. Without prejudice to Title III, this part shall apply to the following persons. Union citizens who exercise their right to reside in the United Kingdom in accordance with Union law before the end of the transition period and continue to reside there thereafter. B. United Kingdom nationals who exercise their right to reside in a member state in accordance with Union law before the end of the transition period and continue to reside there thereafter. C. Union citizens who exercise their right as frontier workers in the United Kingdom in accordance with Union law before the end of the transition period and continue to do so thereafter. D. United Kingdom nationals who exercise their right as frontier workers in one or more member states in accordance with Union law before the end of the transition period and continue to do so thereafter. E. Family members of the persons referred to in point up to D. Provided that they fulfill one of the following conditions. I. They resided in the host state in accordance with Union law before the end of the transition period and continue to reside there thereafter. II. They were directly related to a person referred to in point up to D. and resided outside the host state before the end of the transition period, provided that they fulfill the conditions set out in point 2 of Article 2 of Directive 2004/38/EC at the time they seek residence under this part in order to join the person referred to in point up to D of this paragraph. III. They were born to, or legally adopted by, persons referred to in point up to D after the end of the transition period, whether inside or outside the host state, and fulfill the conditions set out in point 2. C. of Article 2 of Directive 2004/38/EC at the time they seek residence under this part in order to join the person referred to in point to D of this paragraph and fulfill one of the following conditions. Both parents or persons referred to in point up to D. One parent is a person referred to in point up to D, and the other is a national of the host state, or one parent is a person referred to in point up to D, and has sole or joint rights of custody of the child, in accordance with the applicable rules of family law of a member state or of the United Kingdom, including applicable rules of private international law under which rights of custody established under the law of a third state are recognized in the member state or in the United Kingdom, in particular as regards the best interests of the child, and without prejudice to the normal operation of such applicable rules of private international law. 1f. Family members who resided in the host state in accordance with Articles 12 and 13, Article 16, 2, and Articles 17 and 18 of Directive 2004/38/EC before the end of the transition period and continue to reside there thereafter. 1. The notion of rights of custody is to be interpreted in accordance with point 9. Of Article 2 of Regulation, EC, No. 2201/2003. Therefore, it covers rights of custody acquired by judgment, by operation of law or by an agreement having legal effect to persons falling under point N, B, of Article 3, 2, of Directive 2004/38/EC whose residence was facilitated by the host state in accordance with its national legislation before the end of the transition period in accordance with Article 3, 2, of that directive shall retain their right of residence in the host state in accordance with this part, provided that they continue to reside in the host state thereafter. 3. Paragraph 2 shall also apply to persons falling under point N, B, of Article 3, 2, of Directive 2004/38/EC who have applied for facilitation of entry and residence before the end of the transition period, and whose residence is being facilitated by the host state in accordance with its national legislation thereafter. 4. Without prejudice to any right to residence which the persons concerned may have in their own right, the host state shall, in accordance with its national legislation and in accordance with point B of Article 3, 2, of Directive 2004/38/EC, facilitate entry and residence for the partner with whom the person referred to in point to D of paragraph 1 of this article has a durable relationship, duly attested, where that partner resided outside the host state before the end of the transition period, provided that the relationship was durable before the end of the transition period and continues at the time the partner seeks residence under this part. 5. In the cases referred to in paragraphs 3 and 4, the host state shall undertake an extensive examination of the personal circumstances of the persons concerned and shall justify any denial of entry or residence to such persons. Article 11 Continuity of residence for the purposes of Articles 9 and 10 shall not be affected by absences as referred to in Article 15. 2. The right of permanent residence acquired under Directive 2004/38/EC before the end of the transition period shall not be treated as lost through absence from the host state for a period specified in Article 15. 3. Article 12 Non-discrimination within the scope of this part, and without prejudice to any special provisions contained therein. Any discrimination on grounds of nationality within the meaning of the first subparagraph of Article 18 TFEU shall be prohibited in the host state in the state of work in respect of the persons referred to in Article 10 of this agreement. Title II Rights and Obligations Chapter 1 Rights related to residence. Residence Documents Article 13 Residence Rights 1. Union citizens and United Kingdom nationals shall have the right to reside in the host state under the limitations and conditions as set out in Articles 21, 45 or 49 TFEU and in Article 6, 1, points, A, B, or C, of Article 7, 1, Article 7, 3, Article 14, Article 16, 1, or Article 17, 1, of Directive 2004/38/EC2. Family members who are either Union citizens or United Kingdom nationals shall have the right to reside in the host state as set out in Article 21 TFEU and in Article 6, 1, point D, of Article 7, 1, Article 12, 1, or 3, Article 13, 1, Article 14, Article 16, 1, or Article 17, 3, and 4, of Directive 2004/38/EC, subject to the limitations and conditions set out in those provisions. 3. Family members who are neither Union citizens nor United Kingdom nationals shall have the right to reside in the host state under Article 21 TFEU and as set out in Article 6, 2, Article 7, 2, Article 12, 2, or 3, Article 13, 2, Article 14, Article 16, 2, Article 17, 3, or 4, or Article 18 of Directive 2004/38/EC, subject to the limitations and conditions set out in those provisions. 4. The host state may not impose any limitations or conditions for obtaining, retaining or losing residence rights on the persons referred to in paragraphs 1, 2 and 3, other than those provided for in this title. There shall be no discretion in applying the limitations and conditions provided for in this title, other than in favor of the person concerned. Article 14 Right of Exit and of Entry 1. Union citizens and United Kingdom nationals, their respective family members, and other persons who reside in the territory of the host state in accordance with the conditions set out in this title shall have the right to leave the host state and the right to enter it, as set out in Article 4, 1, and the first subparagraph of Article 5, 1, of Directive 2004/38/EC. With a valid passport or national identity card in the case of Union citizens and United Kingdom nationals, and with a valid passport in the case of their respective family members and other persons who are not Union citizens or United Kingdom nationals. 5 years after the end of the transition period, the host state may decide no longer to accept national identity cards for the purposes of entry to or exit from its territory if such cards do not include a chip that complies with the applicable International Civil Aviation Organization standards related to biometric identification. 2. No exit visa. Entry visa or equivalent formality shall be required of holders of a valid document issued in accordance with Article 18 or 26. 3. Where the host state requires family members who join the Union citizen or United Kingdom national after the end of the transition period to have an entry visa, the host state shall grant such persons every facility to obtain the necessary visas. Such visas shall be issued free of charge as soon as possible, and on the basis of an accelerated procedure. Article 15 Right of Permanent Residence 1. Union citizens and United Kingdom nationals, and their respective family members, who have resided legally in the host state in accordance with Union law for a continuous period of 5 years or for the period specified in Article 17 of Directive 2004/38/EC, shall have the right to reside permanently in the host state under the conditions set out in Articles 16, 17 and 18 of Directive 2004/38/EC. Periods of legal residence or work in accordance with union law before and after the end of the transition period shall be included in the calculation of the qualifying period necessary for acquisition of the right of permanent residence. 2. Continuity of residence for the purposes of acquisition of the right of permanent residence shall be determined in accordance with Article 16.3 and Article 21 of Directive 2004/38/EC3. Once acquired, the right of permanent residence shall be lost only through absence from the host state for a period exceeding 5 consecutive years. Article 16. Accumulation of periods. Union citizens and United Kingdom nationals, and their respective family members, who before the end of the transition period resided legally in the host state in accordance with the conditions of Article 7 of Directive 2004/38/EC for a period of less than 5 years, shall have the right to acquire the right to reside permanently under the conditions set out in Article 15 of this agreement once they have completed the necessary periods of residence. Periods of legal residence or work in accordance with union law before and after the end of the transition period shall be included in the calculation of the qualifying period necessary for acquisition of the right of permanent residence. Article 17. Status and changes. 1. The right of union citizens and United Kingdom nationals, and their respective family members, to rely directly on this part shall not be affected when they change status. For example, between student, worker, self-employed person and economically inactive person. Persons who, at the end of the transition period, enjoy a right of residence in their capacity as family members of Union citizens or United Kingdom nationals, cannot become persons referred to in points up to D of Article 10(1)(2). The rights provided for in this title for the family members who are dependents of Union citizens or United Kingdom nationals before the end of the transition period shall be maintained even after they cease to be dependents. Article 18. Issuance of residence documents. 1. The host state may require Union citizens or United Kingdom nationals, their respective family members and other persons who reside in its territory in accordance with the conditions set out in this title, to apply for a new resident status which confers the rights under this title and a document evidencing such status which may be in a digital form. Applying for such a resident status shall be subject to the following conditions. The purpose of the application procedure shall be to verify whether the applicant is entitled to the residence rights set out in this title. Where that is the case, the applicant shall have a right to be granted the resident status and the document evidencing that status. B. The deadline for submitting the application shall not be less than 6 months from the end of the transition period. For persons residing in the host state before the end of the transition period, for persons who have the right to commence residence after the end of the transition period in the host state in accordance with this title, the deadline for submitting the application shall be 3 months after their arrival or the expiry of the deadline referred to in the first subparagraph, whichever is later. A certificate of application for the resident status shall be issued immediately. D. The deadline for submitting the application referred to in point B shall be extended automatically by 1 year where the Union has notified the United Kingdom, or the United Kingdom has notified the Union, that technical problems prevent the host state either from registering the application or from issuing the certificate of application referred to in point B. The host state shall publish that notification and shall provide appropriate public information for the persons concerned in good time. D. Where the deadline for submitting the application referred to in point B is not respected by the persons concerned, the competent authorities shall assess all the circumstances and reasons for not respecting the deadline and shall allow those persons to submit an application within a reasonable further period of time if there are reasonable grounds for that. failure to respect the deadline. E. The host state shall ensure that any administrative procedures for applications are smooth, transparent and simple, and that any unnecessary administrative burdens are avoided. F. Application form shall be short, simple, user-friendly and adapted to the context of this agreement. Applications made by families at the same time shall be considered together. G. The document evidencing the status shall be issued free of charge or for a charge not exceeding that imposed on citizens or nationals of the host state for the issuing of similar documents. A. Persons who, before the end of the transition period, hold a valid permanent residence document issued under Article 19 or 20 of Directive 2004/38/EC or hold a valid domestic immigration document conferring a permanent right to reside in the host state, shall have the right to exchange that document within the period referred to in point B of this paragraph for a new residence document upon application after a verification of their identity, a criminality and security check in accordance with point P of this paragraph and confirmation of their ongoing residence. Such new residence documents shall be issued free of charge. I. The identity of the applicants shall be verified through the presentation of a valid passport or national identity card for Union citizens and United Kingdom nationals, and through the presentation of a valid passport for their respective family members and other persons who are not Union citizens or United Kingdom nationals. The acceptance of such identity documents shall not be made conditional upon any criteria other than that of the validity of the document, where the identity document is retained by the competent authorities of the host state while the application is pending. The host state shall return that document upon application without delay, before the decision on the application has been taken. J. Supporting documents other than identity documents, such as civil status documents, may be submitted in copy. Originals of supporting documents may be required only in specific cases where there is a reasonable doubt as to the authenticity of the supporting documents submitted. K. The host state may only require Union citizens and United Kingdom nationals to present, in addition to the identity documents referred to in point I of this paragraph, the following supporting documents as referred to in Article 8.3 of Directive 2004/38/EC, I, where they reside in the host state in accordance with point of Article 7.1 of Directive 2004/38/EC as workers or self-employed, a confirmation of engagement from the employer or a certificate of employment, or proof that they are self-employed. II, where they reside in the host state in accordance with point B. Of Article 7.1 of Directive 2004/38/EC as the economically inactive persons. Evidence that they have sufficient resources for themselves and their family members not to become a burden on the social assistance system of the host state during their period of residence and that they have comprehensive sickness insurance cover in the host state, or III, where they reside in the host state in accordance with point D of Article 7.1 of Directive 2004/38/EC as student. Proof of enrollment at an establishment accredited or financed by the host state on the basis of its legislation or administrative practice. Proof of comprehensive sickness insurance cover, and a declaration or equivalent means of proof that they have sufficient resources for themselves and their family members not to become a burden on the social assistance system of the host state during their period of residence. The host state may not require such declarations to refer to any specific amount of resources. With regard to the condition of sufficient resources, Article 8.4 of Directive 2004/38/EC shall apply. L. The host state may only require family members who fall under point E.I. of Article 10.1 or Article 10.2 or 3 of this agreement and who reside in the host state in accordance with point D of Article 7.1 or Article 7.2 of Directive 2004/38/EC to present, in addition to the identity documents referred to in point I of this paragraph, the following supporting documents as referred to in Article 8. (5) or 10.2 of Directive 2004/38/EC. I. A document attesting to the existence of a family relationship or registered partnership. II. The registration certificate or, in the absence of a registration system, any other proof that the Union citizen or the United Kingdom national with whom they reside actually resides in the host state. III. For direct descendants who are under the age of 21 or who are dependents and dependent direct relatives in the ascending line, and for those of the spouse or registered partner, documentary evidence that the conditions set out in point D or D. of Article 2.2 of Directive 2004/38/EC are fulfilled. I. For the persons referred to in Article 10.2 or 3 of this agreement, a document issued by the relevant authority in the host state in accordance with Article 3.2 of Directive 2004/38/EC, with regard to the condition of sufficient resources as concerns family members who are themselves Union citizens or United Kingdom nationals. Article 8.4 of Directive 2004/38/EC shall apply, and the host state may only require family members who fall under point E.I. of Article 10.1 or Article 10.4 of this agreement to present, in addition to the identity documents referred to in point I of this paragraph, the following supporting documents as referred to in Articles 8, 5, and 10.2 of Directive 2004/38/EC. I. A document attesting to the existence of a family relationship or of a registered partnership. II. The registration certificate or, in the absence of a registration system, any other proof of residence in the host state of a Union citizen or of the United Kingdom nationals whom they are joining in the host state. III. For spouses or registered partners, a document attesting to the existence of a family relationship or a registered partnership before the end of the transition period. I. For direct descendants who are under the age of 21 or who are dependents and dependent direct relatives in the ascending line and those of the spouse or registered partner, documentary evidence that they were related to Union citizens or United Kingdom nationals before the end of the transition period and fulfill the conditions set out in point D or D of Article 2.2 of Directive 2004/38/EC relating to age or dependent. V. For the persons referred to in Article 10.4 of this agreement, proof that a durable relationship with Union citizens or United Kingdom nationals existed before the end of the transition period and continues to exist thereafter. N. For cases other than those set out in point K, L, N, M, the host state shall not require applicants to present supporting documents that go beyond what is strictly necessary and proportionate to provide evidence that the conditions relating to the right of residence under this title have been fulfilled. O. The competent authorities of the host state shall help the applicants to prove their eligibility and to avoid any errors or omissions in their applications. They shall give the applicants the opportunity to furnish supplementary evidence and to correct any deficiencies. Errors or omissions. P. Criminality and security checks may be carried out systematically on applicants, with the exclusive aim of verifying whether the restrictions set out in Article 20 of this agreement may be applicable. For the purpose, applicants may be required to declare past criminal convictions which appear in their criminal record in accordance with the law of the state of conviction at the time of the application. The host state may, if it considers this essential, apply the procedure set out in Article 27. 3. Of Directive 2004/38/EC with respect to inquiries to other states regarding previous criminal records. Q. The new residence document shall include a statement that it has been issued in accordance with this agreement. R. The applicant shall have access to judicial and, where appropriate, administrative redress procedures in the host state against any decision refusing to grant the residence status. The redress procedure shall allow for an examination of the legality of the decision. As well as of the facts and circumstances on which the proposed decision is based. Such redress procedure shall ensure that the decision is not disproportionate to, during the period referred to in point B of paragraph 1 of this article and its possible one-year extension under point D of that paragraph. All rights provided for in this part shall be deemed to apply to Union citizens or United Kingdom nationals. Their respective family members, and other persons residing in the host state, in accordance with the conditions and subject to the restrictions set out in Article 20. 3. Pending a final decision by the competent authorities on any application referred to in paragraph 1, and pending a final judgment handed down in case of judicial redress sought against any rejection of such application by the competent administrative authorities. All rights provided for in this part shall be deemed to apply to the applicant, including Article 21 on safeguards and right of appeal, subject to the conditions set out in Article 20. 4. Where a host state has chosen not to require Union citizens or United Kingdom nationals, their family members, and other persons residing in its territory in accordance with the conditions set out in this title, to apply for the new residence status referred to in paragraph 1 as a condition for legal residence. Those eligible for residence rights under this title shall have the right to receive, in accordance with the conditions set out in Directive 2004/38/EC, a residence document, which may be in a digital form, that includes a statement that it has been issued in accordance with this agreement. Article 19 Issuance of residence documents during the transition period. 1. During the transition period, a host state may allow applications for a residence status or residence document as referred to in Article 18, 1, and 4, to be made voluntarily from the date of entry into force of this agreement. 2. Decisions to accept or refuse such applications shall be taken in accordance with Article 18, 1, and 4. Decisions under Article 18, 1, shall have no effect until after the end of the transition period. 3. If an application under Article 18, is accepted before the end of the transition period, the host state may not withdraw the decision granting the residence status before the end of the transition period on any grounds other than those set out in Chapter VI and Article 35 of Directive 2004/38/EC4. If an application is refused before the end of the transition period, the applicant may apply again at any time before the expiry of the period set out in point B of Article 18, 1.5. Without prejudice to paragraph 4, the redress procedures under point R of Article 18, 1, shall be available from the date of any decision to refuse an application referred to in paragraph 2 of this article. Article 20 Restrictions of the Rights of Residents and Entry 1. The conduct of Union citizens or United Kingdom nationals, their family members, and other persons who exercise rights under this title, where that conduct occurred before the end of the transition period, shall be considered in accordance with Chapter VI of Directive 2004/38/EC2. The conduct of Union citizens or United Kingdom nationals, their family members, and other persons who exercise rights under this title, where that conduct occurred after the end of the transition period, may constitute grounds for restricting the right of residence by the host state or the right of entry in the state of work in accordance with national legislation. 3. The host state or the state of work may adopt the necessary measures to refuse, terminate or withdraw any right conferred by this title in the case of the abuse of those rights or fraud, as set out in Article 35 of Directive 2004/38/EC. Such measures shall be subject to the procedural safeguards provided for in Article 21 of this agreement. 4. The host state or the state of work may remove applicants who submitted fraudulent or abusive applications from its territory under the conditions set out in Directive 2004/38/EC, in particular Articles 31 and 35 thereof, even before a final judgment has been handed down in the case of judicial redress sought against any rejection of such an application. Article 21 Safeguards and right of appeal. The safeguards set out in Article 15 and Chapter VI of Directive 2004/38/EC shall apply in respect of any decision by the host state that restricts residence rights of the persons referred to in Article 10 of this agreement. Article 22 Related rights. In accordance with Article 23 of Directive 2004/38/EC, irrespective of nationality, the family members of a Union citizen or United Kingdom national who have the right of residence or the right of permanent residence in the host state or the state of work shall be entitled to take up employment or self-employment there. Article 23 Equal treatment. 1. In accordance with Article 24 of Directive 2004/38/EC, subject to the specific provisions provided for in this title and Titles I and IV of this part, all Union citizens or United Kingdom nationals residing on the basis of this agreement in the territory of the host state shall enjoy equal treatment with the nationals of that state within the scope of this part. The benefit of this right shall be extended to those family members of Union citizens or United Kingdom nationals who have the right of residence or permanent residence. 2. By way of derogation from paragraph 1, the host state shall not be obliged to confer entitlement to social assistance during periods of residence on the basis of Article 6 or point B of Article 14. 4. Of Directive 2004/38/EC. Nor shall it be obliged, prior to a person's acquisition of the right of permanent residence in accordance with Article 15 of this agreement, to grant maintenance aid for studies, including vocational training, consisting in student grants or student loans to persons other than workers, self-employed persons, persons who retain such status, or to members of their families. Chapter 2 Rights of Workers and Self-Employed Persons. Article 24 Rights of Workers. 1. Subject to the limitations set out in Article 45, 3, and 4, TFEU. Workers in the host state and frontier workers in the state or states of work shall enjoy the rights guaranteed by Article 45 TFEU and the rights granted by Regulation (EU) No. 492/2011 of the European Parliament and of the Council. 1. These rights include a. The right not to be discriminated against on grounds of nationality as regards employment, remuneration and other conditions of work and employment. B. The right to take up and pursue an activity in accordance with the rules applicable to the nationals of the host state or the state of work. C. The right to assistance afforded by the employment offices of the host state or the state of work is offered to own nationals. 1. Regulation (EU) No. 492/2011 of the European Parliament and of the Council of April 5, 2011 on freedom of movement for workers within the Union. OJL 141, May 27, 2011. Page 1. D. The right to equal treatment in respect of conditions of employment and work, in particular as regards remuneration, dismissal and in case of unemployment, reinstatement or reemployment. E. The right to social and tax advantages. F. Collective right. G. The rights and benefits accorded to national workers in matters of housing. H. The right for their children to be admitted to the general educational, apprenticeship and vocational training courses under the same conditions as the nationals of the host state or the state of work, if such children are residing in the territory where the worker works to, where a direct descendant of a worker who has ceased to reside in the host state is in education in its state. The primary carer for that descendant shall have the right to reside in that state until the descendant reaches the age of majority, and after the age of majority if that descendant continues to need the presence and care of the primary carer in order to pursue and complete his or her education. 3. Employed frontier workers shall enjoy the right to enter and exit the state of work in accordance with Article 14 of this agreement and shall retain the rights they enjoyed as workers there, provided they are in one of the circumstances set out in point A, B, C, and D of Article 7. 3. Of Directive 2004/38/EC, even where they do not move their residence to the state of work. Article 25 Rights of Self-Employed Persons 1. Subject to the limitations set out in Articles 51 and 52 TFEU. Self-employed persons in the host state and self-employed frontier workers in the state or states of work shall enjoy the rights guaranteed by Articles 49 and 55 TFEU. These rights include A. The right to take up and pursue activities as self-employed persons and to set up and manage undertakings under the conditions laid down by the host state for its own nationals, as set out in Article 49 TFEU. B. The rights as set out in point C. 2. 8 of Article 24, 1 of this agreement. 2. Article 24, 2 shall apply to direct descendants of self-employed workers. 3. Article 24, 3 shall apply to self-employed frontier workers. Article 26 Issuance of a document identifying frontier workers' rights. The state of work may require Union citizens and United Kingdom nationals who have rights as frontier workers under this title to apply for a document certifying that they have such rights under this title. Such Union citizens and United Kingdom nationals shall have the right to be issued with such a document. Chapter 3 Professional Qualifications. Article 27 Recognized Professional Qualifications. 1. The recognition, before the end of the transition period, of professional qualifications, as defined in point B of Article 3, 1 of Directive 2005/36/EC of the European Parliament and of the Council. 1. Of Union citizens or United Kingdom nationals, and their family members, by their host state or their state of work shall maintain its effects in the respective state, including the right to pursue their profession under the same conditions as its nationals.
This month.
Where such recognition was made in accordance with any of the following provisions. Title II of Directive 2005/36/EC in respect of the recognition of professional qualifications in the context of the exercise of the freedom of establishment, whether such recognition fell under the general system for the recognition of evidence of training, the system for the recognition of professional experience, or the system for the recognition on the basis of coordination of minimum training conditions. 1. Directive 2005/36/EC of the European Parliament and of the Council of September 7, 2005 on the recognition of professional qualifications. OJL 255. September 30, 2005. Page 22. B. Article 10, 1, and 3 of Directive 98/5/EC of the European Parliament and of the Council 1 in respect of gaining admission to the profession of lawyer in the host state or state of work. C. Article 14 of Directive 2006/43/EC of the European Parliament and of the Council 2 in respect of the approval of statutory auditors from another member state. D. Council Directive 74/556/3 in respect of the acceptance of evidence of the knowledge and ability necessary to take up or pursue the activities of self-employed persons and of intermediaries engaging in the trade and distribution of toxic products or activities involving the professional use of toxic products. 1 Directive 98/5/EC of the European Parliament and of the Council of February 16, 1998 to facilitate practice of the profession of lawyer on a permanent basis in a member state other than that in which the qualification was obtained. OJL 77, March 14, 1998. Page 36. 2 Directive 2006/43/EC of the European Parliament and of the Council of May 17, 2006 on statutory audits of annual accounts and consolidated account. Amending Council Directive 78/660/EC and 83/349/EC and repealing Council Directive 84/253/E. OJL 157, September 6, 2006. Page 87. Free Council Directive 74/556/EC of June 4, 1974 laying down detailed provisions concerning transitional measures relating to activities, trade in and distribution of toxic products and activities entailing the professional use of such products including activities of intermediaries. OJL 307, November 18, 1974. Page 12. Recognitions of professional qualifications for the purposes of point of paragraph 1 of this article shall include recognitions of professional qualifications which have benefited from Article 3 of Directive 2005/36/EC. B. Decisions granting partial access to a professional activity in accordance with Article 4F of Directive 2005/36/EC. D. Recognitions of professional qualifications for establishment purposes made under Article 4D of Directive 2005/36/EC. Article 28 Ongoing procedures on the recognition of professional qualifications. Article 4. Article 4D in respect of recognitions of professional qualifications for establishment purposes. Article 4F entitled III of Directive 2005/36/EC. Article 10, 1, 3, and 4 of Directive 98/5/EC. Article 14 of Directive 2006/43/EC and Directive 74/556 each shall apply in respect of the examination by a competent authority of the host state or state of work of any application for the recognition of professional qualifications introduced before the end of the transition period by Union citizens or United Kingdom nationals and in respect of the decision on any such application. Articles 4A, 4B and 4E of Directive 2005/36/EC shall also apply to the extent relevant for the completion of the procedures for the recognitions of professional qualifications for establishment purposes under Article 4D of that directive. Article 29 Administrative Cooperation on Recognition of Professional Qualifications 1. With regard to the pending applications referred to in Article 28, the United Kingdom and the Member States shall cooperate in order to facilitate the application of Article 28. Cooperation may include the exchange of information, including information on disciplinary action or criminal sanctions taken or any other serious and specific circumstances which are likely to have consequences for the pursuit of the activities falling under the directives referred to in Article 28. 2. by way of derogation from Article 8, for a period not exceeding 9 months from the end of the transition period, the United Kingdom shall be entitled to use the Internal Market Information System in respect of applications referred to in Article 28 insofar as they concern procedures for the recognition of professional qualifications for establishment.
Withdrawal of the United Kingdom of Great Britain and Northern Ireland from the European Union and the European Atomic Energy Community.